Hey everyone, hey, this is Brenda with Your Life Matter. It is just so awesome today here in Washington. The sun is shining, although the temperature is just dropping a little bit, just a little chilly. But it is so awesome to be with you here today. Hey, look, we're changing it up because at the end of every month, it's Business Wednesday. And I'm so excited because I get the chance to support local business in our community and to learn what they do and how their services can help you. So this is a wonderful time to introduce my special guest and friend. This is Eric Walters. He is an attorney for Harlow and Fox here in Tacoma. Is that correct?
That's right.
Hey, Eric, give a shout out. Say hello.
Hey, everybody. How you doing?
That's all right. So this is just so wonderful. And Eric's going to be here to at least educate us in regards to estate planning and wills. That's right. It's the dreaded thing that we really hate to get involved in. But you know what? We need to hit it early versus at the end. And you know what I'm talking about at the end? It's before the person passes away. So we want to be ready before that time comes because, you know, paperwork can be mundane, but you need a good lawyer like Eric to help you through the process. So let's get started here. Eric, thank you so much for coming in.
Yeah, thanks for having me, Brenda. It's good to be here.
Oh, it is so wonderful. And you know what, Eric? These are the three things that's very challenging for families to get into, which is estate planning, wills, all right, and from there, and also learning about probate. Why is that a challenge? Why is that a sore for some people to get involved in?
Oh, it's heavy stuff for sure, right?
Yes.
We like to be alive. We don't want to think about our eventual passing, and it's something that's easy to push off as well. You know, we're all pretty good at procrastinating. At least most of us are, right? And that's something that you kind of think, well, I'll get to it. I'll get to it. It's kind of in the back of the mind, but oftentimes it takes a larger event, you know, maybe somebody else in the family passes away before you begin to realize, I should probably get this done.
You know, but some people, they're saying, well, I don't have a lot of things like some people, middle class or rich people, you know, do. So why is all this important for me if I don't have such a dollar amount, like 50,000 I have to worry about giving away or 100,000? Why is it so important?
Right. So, and that's a great question just because it's a lot of people think it's just a matter of having a will, right? And we would need to talk about what is it that a will actually accomplishes. You know, and this is why we talk more broadly in terms of estate planning, right? Because what we want to do is we want to put a plan in place that works for your situation, your family, and kind of what your wishes are given your particular circumstance and your situation. You know, wills are usually fairly basic documents where you can indicate where you want your property to go after you pass away. But the catch there is that it only applies to certain types of property, and that's something that most people aren't aware of. Is there's a lot of property that people own these days that actually isn't even controlled by your will. So you need to make plans for how that's going to be passed after your death.
Oh my goodness.
So, you know, a really a good example of that is a retirement account. So your 401ks, your 403bs, your IRAs, you know, anybody that's got one of those knows that when you first sign up, you're supposed to designate a beneficiary of that account, right? And you know, most people put their spouse on that or their children. And it's that beneficiary designation that's essentially a contract, and that's what controls where that property goes, where that account goes after you die.
Wow, that is amazing. You just blew my mind already. You know, all these little technicalities of what really is relevant to be in a will or not. This is the reason why we need a lawyer.
Well, it's so, and my apologies to the global fast food chain, but you know, you can do McDonald's estate planning, or you can do you know, more robust, in-depth estate planning. And if you do the latter, you're less likely to, or your heirs anyway, are less likely to get indigestion after you pass away.
Now, you just brought up my next question was, you know, there's so many of do-it-yourself wills that you can get from Office Depot and stuff like that. What are some of have you seen any, and what problems have they created for the family?
You know, again, it depends on the circumstance. It may be the case that one of those works just fine, but it's a situation where you don't know what you don't know. And so if you're unfamiliar with the estate planning world and you're just pulling something offline, or you buy a prepackaged plan or something like that, Again, maybe it works out just fine, but there are all sorts of different considerations that might not be anticipated by those plans. Certainly, if you've accumulated a good amount of wealth, there are things that those kinds of packages aren't going, at least from what I've seen, they're not going to contemplate. So, if you wanted to set up trusts for any of your family members, by and large, those products aren't going to do that. Um, and there's other things. There may be some family dynamics, right? That it would be helpful to talk that over with a lawyer to figure out, okay, what's the best way to structure this, so that we can take these family dynamics into account. Those prepackaged programs probably aren't going to do that either. One that I'm getting more and more into is the question of planning for family members that have special needs or disabilities.
Oh, that's important.
And again, those prepackaged programs aren't going to have those kinds of provisions or those planning avenues, right? Because that requires a little bit more of a specialized take on your plan to do that kind of stuff.
So, Eric, how does someone contact you to be able to get some more information about that, especially for special needs, because that's also a big question?
Sure. You can reach me by phone, 253-284-4419. You can email me, ewalters@harlowfalk.com. That's EWALTERS at HARLOWEFALK.com. And I can send you, if you contact me, reach out, I'm happy to send you a questionnaire that I like to have my clients fill out just so I can get a sense for what your family's like, what kind of property you have, what sort of planning we need to do. Essentially, it's to get a snapshot so I can sort of do an assessment about what needs to happen.
Now, folks, let me tell you how important a questionnaire is, because I have to explain this to you. My husband, went home. My mother-in-law, she passed away. But before she did, she was cognizant. She was in her right mind. When he was trying to put all her personal effects in order, she thought her will, all right, was signed.
Oh, dear.
All right. The thing about this is, I think is it nationwide that the person has to be cognizant to make decisions and sign documents?
You have to have a certain level of what the law calls capacity or competency to be able to sign a will. It's a fairly low threshold. Basically, you have to know who you are and what the law calls the objects of your bounty. In other words, the people that you want to leave your property to.
Right.
And you have to understand what property you have. So it's a fairly low threshold. But all the same, yeah. I mean, if you've lost your marbles, you're kind of out of luck.
Kind of out of luck. So let me tell you, lucky enough, my mother-in-law was competent to be able to sign the documents. My husband had to find another lawyer to be making sure that the last will that she had drafted was legal, so that it could be properly notarized and done before she passed. This was on her deathbed. So, folks, this is so important. And Eric's bringing some wonderful information on why this is so crucial in regards to doing this.
And if I may add, Brenda, that's again something that's easy to overlook if you're trying to do this yourself, is that there are these signing requirements for your legal documents, your will in particular. You've got to have at least a couple of witnesses there, and there's a special affidavit that's used that needs to be notarized. And again, these are the kinds of technicalities that are easy to overlook if you're trying to do this yourself. And so you think you've got it done, but it turns out that it wasn't signed properly or witnessed properly, and then you're not in the best place.
Understood.
At that point.
Yes. Oh, understood. Let's see if we can pull up. We have some bullet points here that we want to show, if that's possible. You'll be able to see it on the screen. So, Eric, I want to talk about some of these bullet points.
Sure.
This is about the estate letter. All right, a sample that you provided to me. And folks, as you see it on your screen, it's so important and to look at these. So one of them is keeping a written log of work done for the estate. Why is that important?
Yeah, so this has to do with probate work, right? So when we're talking about, I'm a trust and estates lawyer, and so I'm kind of on both the front end and the back end of a person's death, right? We want to do the planning on the front end, which is the estate planning, the wills, other things like that. On the back end, after a person passes away, it may be necessary to do a probate, which is simply it's a court-supervised procedure to make sure that property goes to whoever it's supposed to go to, and that somebody's authorized to wrap up the deceased person's affairs. And so this, for example, has to do with that probate process where somebody is appointed by the court to stand in the shoes of the person who died and to wrap up these affairs. And again, this first point here, it's very important for that person just to keep a log, to keep track of what it is that they're doing. There are a number of reasons for that. One is that that person generally has a right to be compensated for their work. And the other two is to document for the others who are interested in the estate that, hey, look, this is what I'm doing. If questions come up or if there are disputes about things, it's right there in the log that, hey, this is what I've been working on, and this is the time that it spent me, and this is where we are.
Awesome. Let's go to another one here. We got getting a tax number, an EIN for the estate. That kind of threw me off. Why was that important?
Yeah. So it's the fun the fun tax world, right? So an estate of a deceased person is actually its own separate legal entity. It's distinct from anybody else, really, or anything else. And so for that reason, it needs to get a separate tax number in the way that, an individual has a social security number, or a business would have a tax number, or an EIN, an employer identification number. The estate needs to get an employer identification number. Now, the estate's not likely to employ anybody, but you would use that tax number for filing tax returns. More importantly, or at least initially, you're going to want to open up an account for the estate at a bank or credit union or some other financial institution. That way, deposits that the estate receives can be, or monies that the estate receives can be deposited into that account, and any payments can be made from that account. Again, just with the idea that we want to try to keep things separate, above board, everything nice and clear and clean about how we're conducting things.
The one thing I didn't see here, and I might have missed it, we got people who has their own business. How does that affect in regards to the estate planning?
Yeah, that's a big one. So people that have their own business, again, those are the types of people that would certainly benefit from sitting down and talking with an attorney about their plan, about their estate plan. And again, something that's probably not well anticipated in your run-of-the-mill package program. A lot of that's going to depend on what the business is, how it's structured. Are you running your business simply as a sole proprietorship? So it really has no separate legal identity from you. Are you running it as an LLC? Is it a corporation? Are there other owners? If there are other owners, one of the things that it's important to put in place is what we would call a buy-sell agreement, right? That addresses, look, if one of the owners dies, what are we going to do? Is there a buyout that happens at that point in time? Otherwise, you can kind of be left in a little bit of a lurch if an owner dies and there's not really any plan in place, and people can kind of be scrambling to go, okay, well, so-and-so just died. What are we supposed to do with his or her interest in the company? Right. What can happen if you don't have something like that in place is that whoever would have been entitled to the deceased owner's interest in the business under the will or some other document, if it was a trust, then those people can suddenly become perhaps unwanted owners with the current owners of the business. Might not be the situation that people want.
Now, is that something that you or your firm get into as well?
Oh, certainly, yeah.
Well, then let's let the business owners know. How can they contact you if they want to know more about that in regards to estate planning?
Again, just give me a call, 253-284-4419, or send me an email, ewalters@harlowfalk.com. We've got a great team over there of business and planning lawyers who can help.
Awesome. This is very powerful. I just don't know how you keep it all in your head.
I don't. Have you seen the size of our books?
It is just so many, and the thing is, laws changes all the time, don't they?
They do, and it's a matter of continual education, right? And so we have ongoing requirements to stay up to date on things, and I've heard it say it's called law practice because that's admittedly that's what we're doing. We're still practicing our profession.
Understood.
And trying to understand all these nuances and all these details all the time.
Wow, I tell you. Let's look at a couple of other bullet points that you
Sure.
have here. The other thing, notifying the estate beneficiaries and heirs and certain government departments about the probate.
Yeah. So under Washington law, as in most states, if not all, I would suspect, there's a requirement that those who are going to be entitled to some of the property of the deceased person get notice that a probate's open. Number of reasons for this. As a practical matter, it's good transparency. We like transparency. We like people to understand what's going on, who's in charge. Also, people that have an interest in the estate or have rights to contest. And so we need to start the clock on the time frame that they have to contest if they're going to do that.
Now, what's the difference between doing a public notice for family members or siblings and so forth versus creditors? Because I had to go through the same thing
Sure.
now that, they have to make sure that there's no outstanding balance on creditors or so forth before you can be able to touch whatever is
Right.
left.
So I think we'd be talking about different categories of people
Okay.
that have an interest in an estate. So you have your beneficiaries, which are going to be people that are entitled to property under a deceased person's will, right? The will would identify them as receiving property. You have what are called heirs. Heirs are people that are entitled to property if there is no will.
Oh,
Or what the law calls intestacy, or dying intestate without a will. That's what heirs are. And then creditors, of course, are people that they don't have an inheritance right, obviously, but they're people that were owed money or might have been owed money by the deceased person before he or she died. And the difference with the notices, of course, is that when it comes to beneficiaries and heirs, the notices that they're receiving are going to have to do, again, with their rights to put in an objection or to make some sort of a claim that maybe the will was invalid. Whereas with a creditor, that's a notice to them that they have a certain amount of time to file their claim against the estate, or if they don't, then it's time barred. They're done.
right. Now, Eric, tell us about the questionnaire. How would the questionnaire help us so that we are making sure that the pieces that needs to be put together before a person passes away, we were able to establish that and know that we could be able to find the appropriate documents and make this work?
Yeah, so, and this is all interrelated, right? Both the estate planning work on the front end and the probate work on the back end. The idea with the estate planning work is that, look, in anticipation that someday you're going to be gone and your affairs are going to have to be taken care of, what can we do now to set things up to make things easier for those left behind? With the questionnaire, there are a number of different things that we're trying to figure out. One of those is we want to know what property do you own, so that way we can make plans accordingly. Different types of property require different types of planning. We also want to know, who are the important people in your life? Who are the people that, if it came to the point where you couldn't make decisions for yourself, which people would you want making those decisions for you? And that has to do with documents that are called powers of attorney, right? So the power of attorney documents have to do with naming somebody in advance to help you make decisions about your finances, about your health care, again, if you get to that point where you're not able to do that yourself.
Awesome. Now, you brought up one situation which I think is sensitive for a lot of families, and that's families who have family members who are disabled.
Sure.
or handicapped. What trend are you seeing there, and what are some of the challenges that maybe they should be looking out for?
Well, so the biggest issue here for families that have an individual with special needs or a disability is making sure that, if needed, they can keep any sort of government benefits that they might be receiving if they're getting supplemental security income, SSI, or if they're receiving Medicaid benefits. The last thing that we want to do is to make them ineligible for those benefits by giving them property or giving them money. And so because those types of government benefits there's an income requirement and a resource requirement. You can only own so much, and it's a very small amount before you become ineligible for those programs.
Right.
If you leave property behind to a loved one who's in that kind of a condition, again, it can make them ineligible for those benefits, at least for a period of time.
Do you know why that's a challenge? I mean, that kind of confuses me. You'd think that the state would be pleased about that.
Well, the idea is that as a policy matter, the idea is that if this person has other resources that are available to him or her, the disabled person,
Right.
then those should be used first before before the government kicks in to provide those benefits.
Okay.
Um, Now, there are ways around this, though, by using something called a special needs trust. The idea with the special needs trust is that you can set aside the property or the money, the funds that the disabled person would have received, but put it into a trust instead and put somebody else in charge of that trust. And then that person who's in charge, the trustee, can use that property for the benefit of the disabled person above and beyond what the government provides.
Okay.
And that's a way to enhance the quality of life of that disabled individual without jeopardizing their government benefits.
Now, this seems like a very important point here that we really need to focus on, because I didn't know that in regards to that even if somebody was awarded some type of inheritance or some type of funding, behind to keep them going, that's considered an income basically above and beyond what the state says they are allowed it to have.
Yeah, and again, it's not something that a lot of people know much about. And again, it's as we always say in the law, everything kind of depends on the circumstance, right? It may be the case. It may be the case if it's a substantial inheritance. It may be better for them just to go ahead and have it.
Yeah.
Because that's going to be better than what they're going to be able to receive from Medicaid or from their SSI benefits. So there are always options. The question is trying to examine, given what's going on, what's the best course of action here.
So with individuals who may have members that are disabled or are physically challenged, now your office deal with some clients like that.
Yeah.
Okay, from that, let's let people know, for those who are in that situation, how can they be able to get a hold of you and learn more about that?
Yeah, please call me, 253-284-4419, or send me an email at ewalters@harlowfalk.com.
Awesome. Now, Eric, there's some things that you love to do in addition to all of this. You love your seniors. All right. Why don't you share with the audience here, what is it about caring for seniors, about how the law works for seniors that really interests you?
Well, these are individuals that have contributed a lot to our communities. I feel like we certainly have a responsibility to make sure that they're being taken care of, that they're being protected. We want to make sure that that there's a plan for them as well, right? We want to make sure that again that with the time that they have left, that it's a good time for them, right? That they feel some satisfaction from their lives, from their family relationships. And to the extent that I can play a small part in giving them that sense of satisfaction or that sense of peace, as they age, then that's good for me.
So what touched your heartstring on this? What created this interest?
It's kind of hard to say. I think, and this is not very analytical at all, but sometimes you just sort of have these visceral gut reactions or feelings, and that that this is something that you should be doing, and that's just kind of what it was for me.
Awesome.
Yeah.
Awesome.
Not again, like I said, not very rational, but
yes.
But yeah, that's what happened.
Oh my goodness! I'm telling you, Eric, this has been an eye opener. All right, because you have provided more information than I even thought of, especially for those who may have family members who are disabled
Sure.
or physically challenged. I mean, that's a sensitive issue right now in regards to that. Hopefully we can bring you back on, because I have some maybe deeper, darker issues to ask you.
Dear.
Yes, from there. But this has just been so awesome. So tell me, what else do you want the audience to take away from the estate planning and wills?
It's never too late to plan, right? And the sooner that you can do it, the better. And there's always something to be considered, right? And it may be the case that all you need is something very basic, but it's like anything else. It kind of requires that attention and that maintenance over time. I don't know. You got to take care of your car.
Yes.
You got to take care of your estate plan.
Yes, yes. Now, Eric, I know that, many warnings have gone out before. I mean, this is not the first time a message like this will go out all the time. Can you share with the audience, what are some of the mistakes that you have seen all the time that you want to give a warning out to?
You want my horror stories?
If it can fit in a couple of years.
It's Halloween tomorrow, right?
That's right. It's Halloween tomorrow. Might as well get right.
Well, let's see if I can give you a quick summary here. I've handled a case before where a gentleman died out on the East Coast. His mother had a trust here in Washington. The gentleman who died out on the East Coast did not have a will himself and was not married, did not have children. He was supposed to have taken over that trust when his mother died several years before him, but he didn't. And so I was working with my client, who was a family member, to try to figure out who on earth should be, who's entitled to the property in this trust. And it turns out we had nearly 50 beneficiaries
Oh my goodness.
because the family was so large on the maternal side.
Yes.
Just the way that the law worked, if somebody dies without a will. So that's been a bit of a logistical nightmare, just trying to track everybody down, and it's not like anybody's receiving a large amount of money.
Right.
But so that's exceptional. That doesn't happen very often. But that's one of the best horror stories I have. As a more practical matter, it's just if the more you can plan and the more that you can be precise about what you would like to have happen, the less chance there is for disputes to break out among your family when you're gone.
Have you had an opportunity where it was just the last minute? It was just unexpected. What do you do? There was nothing established. I mean, how do you handle those? That's like a crisis moment. How do you handle that?
Well, if we're doing, I guess, what we would call deathbed planning, I mean, we're just trying to get stuff done as quickly as possible. It might not be, exactly what we would have done had there been more time, but again, generally, at least some planning is better than none. And heaven forbid, you wait too long and start the process and die before you finish it. I have had that happen, so
it's not an easy case to work with.
No, it's not.
Oh my goodness. I tell you, Eric, this has just been phenomenal.
Well, thank you, Brenda.
Oh my goodness, yeah, this is just awesome right here. Perfect timing because my young, lovely lady here, Sadie, on the side of me, newly mom. I think this is wonderful information that she received. Yeah, she gave it 2 thumbs up in regards to that. So this is just great. So let's remind the audience now, how can we get a hold of Eric Walters? And if they have any questions, what do they do?
Yeah, give me a call, 253-284-4419. Send me an email, ewalters@harlowfalk.com. Again, I'll put in my lawyerly caveat here. Every situation is different. This is general legal advice. So please call us if you have something particular for us to look at.
So no question is the wrong question.
Well, there are plenty of wrong questions, but we'll smile and deal with them.
There you go. Well, folks, this has just been so awesome here. And I thank Eric for coming here today. It was just so wonderful. Once again, this is your host, Brenda, with Your Life Matters. Until next time, peace, love, and joy.